amicus, my lord. In item 1, suo motu PIL, there was no amicus, my lord.
Oh, yes. In the second case. Oh, yes.
My lord, kindly see the status report. Justice Kataki's report, my lord, and pursuant to that, my lord, we have filed the status report. As per the current status report, entire coal which has been mined illegally and was lying at pithead has been transported to CIL coal depot, my lord. So no coal is now, so far as the inventorized coal is concerned, is lying outside the depot, my lord. That is one, my lord. And then so far as the auction of the seized coal is concerned, under section 21, my lord, steps are being taken in accordance with law, my lord. I kindly see the judgment, the direction of the Honorable Supreme Court in this regard.
Last time we saw the judgment. Last time we saw.
Yes, my lord.
Section 21. Section 21.
Yes, my lord.
Yes.
Your lordship kindly remembers now, my lord, the Justice Kataki was directed by the Honorable Supreme Court to carry out these directions, my lord. And now, as per my latest report, my lord, kindly see my latest report.
So,
point A, at page 2.
Now you have introduced a drone technology.
Yes, my lord. Now, so those aspects are drone and etc., my lord, are being overlooked by the oversight committee constituted by National Green Tribunal, my lord. And for that purpose, my lord, I just wanted to show the judgment of the Honorable Supreme Court in this regard, my lord. 2019 HACC page page 83, my lord.
We'll go through it and then. Yes. So then we'll go through this. We'll hear you in person. Mr. Amit.
Yes, your lordship.
We'll go through the report dated 3rd June 2024.
Yes,
today. We'll go through the report.
Yes,
and we'll hear you because you're returning sometime in the second week of June.
Yeah, next week I will be there, my lord. After 8th, I will be there in Meghalaya.
Yes. A report dated 3rd June 2024 has been produced before this court with regard to the further development based on Kadaki Committee's report. Justice Kadaki. Full stop. In order to enable Advocate General, Mr. Amit, Senior Advocate, to be present before this court in person, to address argument, pose the matter, next date of hearing. All the three cases are connected. 1, 2, 3. All the three are connected.
Yes, my lord. Rising out of the same issue. Rising out of the same issue.
Small problem that we are facing. Item number 2, my lord.
Yes.
Item number 2. My learned senior has filed an affidavit, or in this case, my lord, to allow him to transport the coal which was seized by the government and the auction that he has participated in, my lord. Now, my lord, there is nothing in record in the affidavit to show that the origin of the coal, that 16,000 metric ton, about that participation of the auction, my lord, that, my lord, is again a debatable argument that can place before this honorable.
The auction is not going to take place in 1 week.
No, my lord. What I am saying, auction has already been taken. It has been already given to him, my lord. Now he is before this honorable court for a blanket order. There was a ban by this honorable court for him to export, transport, or purchase the coal, my lord.
Yes.
Now, if my lord may kindly see the affidavit that they have filed, what is the player in the miscase, my lord?
Today's affidavit.
No, my lord. Is a miscase which has been miscase number 1 of 2024.
Second.
Filed in the second in the item number 2. Item number 2, my lord.
This is filed by private party, my lord, seeking permission to transport the coal, my lord.
My lord, I'm appearing on behalf of the who filed the miscase, my lord.
Yes.
My lord,
Before my senior argue this matter, my lord, we find it difficult to. We must. Yes, they should not put dogs.
Everyone is barking.
Everyone is barking.
Yes.
That's
So it symbolizes our questions or
Yes, my lord, what happened in this matter, my lord, we was allowed to file a reply or an objection to this miscase, my lord.
You file.
It is already ready, my lord, because my learned junior is not here, my lord, who has not in a
Stop
position.
it and then we'll hear it in the next date of hearing.
My lord, my lord, my lord.
Yes. What's the matter? All on the same date. Yes.
Well, my lord, this matter had come on Friday also, but there appears to some confusion because there are several prayers in my petition, my lord.
Which one, sir?
I don't know
This
one.
is that gratuity
Not
matter.
it called. I thought you were mentioning, yes.
From the delegates, item number 1.
Well, along with the gratuity, there were some matters regarding the medical reimbursement to the employees of the municipality, my lord. At page 19,
Page?
page 19, 19.
One line of your,
Read petition, my lord.
yes, you have challenged the rules also.
No, but at the same time, it also contains prayer, period number 4, page 19.
Yes.
When it says to
Right,
that,
respondent to medical reimbursement bills.
yes, my lord. So many of this petition before your lordship, they are in the sanitation department. They are to carry on the garbages, and many of them fall sick on this count. And many people died during the COVID, my lord, because disposal of the dead body unit was also conducted by them. But despite that, there is no medical reimbursement. All the corporations of Meghalaya, they are employed.
Last time your junior said we are with regard to only the gratuity.
No, my lord, this also, there was some confusion was there, my lord.
With
So I
respect to
pray that let an affidavit be filed by them.
With respect to that, my lord, they can file a separate petition. It will come up before the single bench.
Not necessarily, my lord.
So how can you see in Madras, these kind of composite prayers will not be allowed. You are taking different relief in one petition.
But my lord, according to
We will give you liberty to challenge insofar as the medical bills are concerned, medical reimbursement are concerned. That also we will consider whether it's a factual one or an admitted one for which a remedy can be granted or not. We will give see, with regard to prayer number D4, with regard to medical reimbursement, liberty is given to the petitioner to work out the remedy in accordance with law. That will grant. And so far as the gratuity is concerned, the issue is already, it has become res judicata. What is reserved?
Item number 2.
See, you remind me, I'll elaborate on that. With regard to medical prayer, I'll elaborate it. This is a transfer issue, 3 months affidavit. Yes, what? Last time we said we did 3 months time. That's the final affidavit. In para number 4 or 3 or 4. Number 3 here. Number 3, she was the previous. Yes. Hmm? Okay. Yes. We'll get the order today. Recording the affidavit.
Hello. Item number 3.
3 months from today. Yes.
May it please the court, my lords.
Yes.
We're before this honorable court in challenge to an order passed by the learned DRT Guwahati, my lords.
Surpassing.
Yes, my lords. Now, let's, before commencing with my submission,
Again, the order of DRT.
DRT Guwahati, my lords.
Appeal.
Not appeal, my lord. A writ petition, my lords. But before commencing with my submissions, my lord, I would like to fairly submit that I'm conscious of the fact that an appeal would not ordinarily lie before the DRT, my lords. But my lords, certain exceptions have been carved out by the Honorable Supreme Court, wherein the Honorable Supreme Court has categorically held that when procedural lapses are done by the DRT, my lord.
So what is the date of the judgment?
Let's 1 month back, my lords.
1 month back.
Yes.
Justice Gawai's judgment.
Yes, my lord, Justice Gawai's judgment, there are certain exceptions were laid down by Honorable Justice Gawai, my lords. And Justice Gawai specifically said that, my lords, when there are certain procedural lapses or when the DRT has not taken sight of certain statutory mandates, then the same can be challenged before the Honorable Court under 226, my lords.
The clear finding of the Supreme Court, more so the last paragraph or last but one paragraph, that when there is an alternate remedy, don't entertain. You go back.
Lords. Paragraph number 29, Lords.
Paragraph number 33.
Yes, my lord.
See, in Madras, we have entertained a matter when the appellate tribunal was not there. Here, the appellate tribunal is there. So, when you have got an effective alternate remedy, otherwise we can simply say admit notice, same order, 25% deposit, then the next hearing we can dismiss the matter.
But let's, if I can just advance my argument, because let's, in paragraph number 33 also, the Honorable Supreme Court says that identifies and acknowledges the principle of discretion which rests with the Honorable High Court, my lords. And that discretion, in my humble submission, Lord.
Understand, you don't read only one paragraph. You must read the entire judgment.
Yes,
the Supreme Court in Satyavati Tandon case has categorically given the guidelines wherein you cannot approach the court bypassing the appellate remedy. Other conditions have also been given. Come, the present appeal has been preferred. The order of the DRT dated so and so. The main contention of the petitioner is that when the statutory authority has not acted in accordance with the provisions of enactment in question, and that there is a violation of principles of natural justice. This court is empowered to entertain the writ petition, dehash the alternate remedy. Full stop. We also relied upon paragraph number 29 of the judgment, which is extracted below. While dealing with those issues, by referring to Satyavati Tandon case reported in so and so, in paragraph 33 of the decision reported in 2024 4 SCR, page number so and so, which is extracted below, has categorically held that the High Court continued to ignore the availability of statutory remedies under the DRT Act and the Sarfasi Act, and the exercise the jurisdiction under Article 226 of the Constitution of India, which is impermissible, and that in future the High Court must exercise greater caution in dealing with those issues. Hence, we are of the view that in the light of the paragraph number 33 of the judgment extracted supra, we dismiss the appeal, writ petition, and permit the petitioner to file the appeal before the appellate tribunal. It should be filed within a period of 30 days from the date of register of the order. In case more time is available in preferring appeal under the statute, that is, the same is not curtailed by the order of this court.
Right.
Item number 4.
My lords, this is
What
the
happened to this acquisition,
acquisition, my lord.
proper compensation?
Yes, my lord. Here, my lord, two issues: how much money excess have been paid, and who is actually entitled to. And this came back from the Supreme Court with the framed issues by the Supreme Court, my lord, and the district judge has done the inquiry, my lord. Previously, there was no specific finding, therefore, the second time. Now, in the second time, my lord, two things has come out, my lord, to my decision, which I like to apprise, my lord. One, there.
Who is appearing on the other side?
Lordship, I appear for respondent 3.
Ready?
Lordship, I was required to file my response to the inquiry report. Lordship, on the last occasion I have paid...
One time.
Lordship, yes, I wanted time. Because these certain documents which are not in my possession. Now I have applied before the registry. Registry said we cannot give you those
You are
documents.
appearing which respondent?
Number 3, Lordship.
See, matter is pending for no.
Lordship, Lordship,
Then it will become decayed.
Lordship, I try my best to procure those documents, but since these entire record are before the Registrar General, it's in seal cover, Lordship. So maybe that liberty may be granted for me.
You going to procure document or create document?
Procure the documents, Lordship. There are certain exhibits which the court has exhibited. Those are not in my possession.
You are appearing for respondent?
3, Lordship.
Respondent number 3.
Maclindo.
No, Patricia.
Patricia Nongsis. Okay. Yes, Patricia Nongsis.
One of the claimant, Lordship.
Ah.
Yes.
One of the claimant, that is respondent 3.
Respondent 3.
Is it not?
Patricia Nongsis.
Lordship, respondent 3.
One of the claimant, who is the respondent number 3, would submit that he has to procure documents from the registry and file a detailed statement before this court in order to enable the justification or otherwise in grant of compensation. So, so Yobin, amicus, would submit that pursuant to the orders of the Supreme Court, the matter has been taken up by the district council,
District Judge, my lord.
district judge,
District Judge, Riboy District.
and decision has been taken, and the matter is pending for more than 3 years, 5 years,
My lord.
more than so many years. Since it is pertaining to grant of compensation while acquiring the lands, we expect the claimant to show greater importance so that they get compensation during the lifetime. This is the case. We said that some 6 points, some crores were there, whether that amount could be given, whether some more amount can be given quite as true. This was the question posed by us.
My lord,
Is it not?
my lord,
Not this case.
no, it is not this case, my lord. Here, my lord, the finding is that 9 crores excess has been paid, my lord, because that is the exact question that was put up before the Supreme Court. The Supreme Court said how much money has been squandered by paying excess amount. So the finding here is 9 crore excess has been paid, my lord.
Well, I would submit that there is no exact finding.
But anyway, we'll see.
Yes.
Lordship, I have
There's no finding.
just one more request, Lordship. Lordship, the entire records of the inquiry are before the Registrar General, Lordship, not before the registry. So that's why I cannot procure those documents from the registry. That is my...
Is there any order saying that it should be kept in a sealed cover? No, no such order. No such order. So any copy application is filed, right? Any copy application is filed to the registry, the papers may be obtained from the Registrar General, with whom the papers are in custody, and 11 documents may be furnished to the petitioner if there are no impediments.
I look.
The inquiry report, I think, are already filed, given to the party.
Report is with me, Your Lordship. There are certain documents which...
Obliged.
Item number 5.
Fine. Yes.
May it please your Lordship. Lordship, so far the proposal made in the early affidavit, except two, those have been complied with your Lordship. Lordship, we filed the affidavit, your Lordship. If Lordship is pleased to kindly come to the affidavit filed by the state, your Lordship.
Oh, this is with regard to traffic.
Lordship, yes.
Right,
Lordship, kindly come to the affidavit, your Lordship. At paragraph at page 5, paragraph 6.
See, this is in Shillong, is it not?
Lordship, yes.
See, I had an occasion to travel in and around Shillong yesterday and day before yesterday. I found everywhere the markets are on the streets. We authorize it, whether they will be having some zone, no?
Lordship, that is that I think another.
So how can the shops be on the streets?
Lordship, that I think there is another PIL also on that.
Entire road, my lord, is occupied from both sides in most of the places.
Both are interconnected because the shops, illegal shops are removed. You are going to have a better road.
Lordship, so far this PIL is with regards to two-wheelers and road safety, your Lordship. So those
The further stated the government requires 3 months time to implement the proposals to the traffic point. Now you asked for February, you asked for 3 months time. Why it's posted today?
Lordship, because
3 months time is over.
we are supposed to file the report, your Lordship. So we have filed the affidavit, your Lordship.
So you find a report.
Yes, your Lordship.
When?
We filed on 31st, your Lordship.
10th of?
31st of
31st
May.
of May, your Lordship.
Oh, 31.5, yes.
Lordship. Lordship, kindly come to page 5 at paragraph 6, Lordship.
One minute. Page number?
Page number, at page 5, your Lordship, paragraph 6.
Ah,
Lordship, we are going to install 300 high-end CCTV, your Lordship.
no, para?
Para 6, your Lordship.
Para 6.
Lordship, yes.
It is further humbly submitted that the government has
Lordship, yes.
proposed.
Lordship, yes.
NCCT cameras with facial
Recognition feature in barriers which is likely to be run from the month of July, your Lordship. So this also will take some time, your Lordship. We are asking for some more time, your Lordship.
Paragraph 7, my lord, they
Then
said
paragraph
that,
7, your Lordship, the government has directed the police to identify, your Lordship, those places.
Oh, the matter is taken up for hearing.
if, my lord, I can point out one simple issue, my lord. My lord, there are some places, my lord, in roads like from Don Bosco Square, when we come down towards the Governor House, it's a slope area, and there are some places where this drain is covered with iron plates. If especially in rainy season, my lord, these plates, if any two-wheeler climbs on top of it, my lord, it slips.
to skid and
Yes, my lord. So if this can be covered with,
no, all those things, put it in a form of an affidavit, so that they will rectify. See, it's a public interest litigation, and you should also cooperate. So it is not a question of blaming other person. If there are any mistakes,
yes,
it has got to be pointed out. See,
Yes.
I'll say mistake means it's a mistake. You can say it is an error.
What I'm submitting, let
You
the
point out those errors so that they can rectify.
let the petitioner ask their suggestion, then your lordship will act accordingly if it is possible, your lordship.
Oh, when the matter is taken for hearing, government advocate appearing for the respondent submitted that he has produced an affidavit dated 31st May 2024, wherein it has been mentioned that steps have been taken to install CCTV cameras and also automatic speed detection devices so that the traffic could be regulated. Also, on the relevant paragraph number 6 and 7 are extracted below. Sir, that is page number 96 and 97. The counsel appearing for the petitioner would submit that there are certain iron girders
plates which is covered
in
in the
the
drawing.
street, and during the rainy season, it causes hindrance, and due to that, accident takes place. Full stop. It is needless to mention that the defects to be eradicated by the government may be pointed out by means of a reply, so that they may take steps to ensure that the accident are minimized. We can't say we cannot stop the accident, it will take place.
It can be
Minimized.
covered with concrete.
Minimized. Full stop. The government leader submitted that they require further time
Lordship.
to carry out the
Exercise. your lordship.
carry out the fixing of installation of CCTV cameras and automatic speed detections, and that the matter may be called after some time. How many times?
If lordship is pleased to grant us 2 weeks or 2 months time, your lordship, another 2 months time, your
The
lordship.
matter on 16th August. 2 months.
Lordship. Apply, your lordship.
Obliged.
Item number 6 to 11.
With these, Your Lordship.
6-2.
These are analogous matters, Your Lordship.
Which matter? What is the matter about, madam?
These are regarding officiating. Your Lordship, on the last day, had asked me to seek instructions from the department and file it by way of an affidavit. Your Lordship, we prepared the affidavit, but on the last minute, we found that there are some corrections to be made, Your Lordship. So we couldn't finalize it.
We are not able to recollect. What
This
is
is
it?
regarding those temporary employees who have come before this court seeking authorization.
33 employees.
31 employees. We've got the
Yes,
instructions,
yes.
Your Lordship. We've got the instructions. We also prepared the affidavits in all the 6, but we found that there were some
Respondent
mistakes.
to file an affidavit. So, as
Require
sought
2
for,
weeks
as sought
time,
for by this court on the earlier occasion. The request of so-and-so pose the matter on
1 week, my lord.
2 weeks' time may be allowed, Your Lordship. There are 6 appeals.
today we are on 1st. Here, June.
Today is the 3rd, Your Lordship.
June.
Obliged, Your Lordship.
Deputy.
Any dates? 3 or more matters? Yes.
Deputy.
Obliged.
Item number 12 to 15.
Enter.
The road GST matter, my lord, GST waiver matter.
Ah. Oh, yes, last time the matter came up, it's covered by the Hero Limited case. On judgment,
Yes, my lord.
no, 2023, 1 SCC 386.
My lord,
Yes, sir.
my lord, I am preparing for the petitioner.
Yes.
My lord, this matter is not at all covered by the Hero Honda case, and I submit for lordship. My lord, the Hero Honda case, you'll also find that there was an excise notification. Am I audible, my lord?
Please see the prayer, sir.
My lord?
Mr. Ashok, please see the
Yes, my-
prayer and the writ petition.
My lord, my lord. Yes, my lord.
Seeking for a
Page
mandamus
30.
My lord,
to be considered.
my lord,
On para number 95 and 96 of the judgment of the Supreme Court.
my lord.
So let them consider and pass orders within a period of 2 weeks or 3 weeks.
No, my lord,
If you challenge it.
my lord, you will also kindly consider, my lord. Every judgment, whenever say that no judgment is applicable, it is applicable on the basis of the facts of the case. Now, in this case, my lord, prior to coming into force of the GST, a promise was made with regard to the GST itself. You will also kindly see the, my lord, the policy, my lord, at page 53.
I think last time Junior appeared.
My lord, because
No,
the
correct.
first day we,
53, 1 minute.
my lord,
Yes.
and relevant part is page 64. My lord, this is the policy.
This is with notification dated 23 May 2017.
My lord, this is the notification dated. This is, in fact, the policy, my lord, Meghalaya 2016 policy. Meghalaya Industrial and Investment Promotional Scheme 2016.
Yes.
And Lordship Meghalaya see page 64.
Yes.
The sales tax benefit. My lord, if I may,
Yes.
my lord, if I may take the policy first, my lord. I am sorry, my lord, I should have taken first. Lordship Meghalaya see page 38, my lord, page 38. I'm sorry, my lord. A relevant part at page 48, my lord.
See, please say your prayer, Mr. Ashok.
Well, I will take you, Lordship. My lord, the prayer has to be on the basis of the, my lord, the whatever the case is there. Your Lordship see page 48, my lord.
See, you cannot expect us to enlarge the scope of the prayer. And
No, I'm not.
let them decide based on your representation and take a decision, and thereafter, if you agree, you challenge it. That's all we can
My
say.
lord, my lord,
Yeah,
Lordship may kindly-
we will give you liberty to raise all the grounds available here now after they take a decision.
But I have submitted the representation. They are not doing it. Your Lordship may kindly
What is the representation?
I am submitting, my lord. Your representations are there.
Where is that?
Well, I'm showing you, Lordship, my lord. There are not only representations from me, but it is from the government side also. Representation letter dated, my lord, page 78. This is first, my lord, this is my letter. I will show, my lord. First, I may show you, Lordship, the letter of the government of Meghalaya itself, my Lordship, Meghalaya, page 78.
Page number?
Page number 78, first letter, my lord, by the director of.
Letter dated
This is the-
78, 1 minute.
Well, I am taking up the petition, my lord.
1 minute,
petition
sir,
number
1 minute. We'll take the page.
My lord, I am taking up petition 119, my lord,
Yes.
WPC 119. WPC 119, my lord.
WP? 119, yes.
Your Lordship is taking up, my lord, petition.
13 July 2018.
My lord. Your
That
Lordship
is
the
the letter of the government.
government, my lord. Your Lordship is the last portion, my lord.
A copy of the resolution is also enclosed.
Now, place it is therefore proposed that we may frame reimbursement scheme for the period from so and so, and a separate scheme by way of refund of the period after with effect from so and so.
Well, Mr. Amit, you take a decision within a period of 2 weeks on the representation. How can you keep the matter pending? So almost 6 years. Not audible.
And one more, Milord. I'm sorry, Milord. One more. Just your lordship for my satisfaction, Milord. Page 48, your lordship may see, Milord. Page 48, Milord.
48.
My lord.
Is that?
Of the petition, Milord.
H1.
H112, Milord.
H1.11.
No, H111, Milord.
H?
111.
Yeah, exactly. I said
And
H.
the last,
H.1.11. Sales tax by Royal Commission.
and the last, Milord, the subpara, Milord, in case of, your lordship, in case of GST.
Becoming applicable to so and so, the policy concern shall be extended to state to GST only.
Only so for the GST.
He'll ask them to take addition with a period of 3 weeks or 4 weeks.
Milord, kindly.
First of all,
kindly-
your junior has filed a writ petition seeking for a mandamus, and there is no representation at all. Registry number.
Well, I will show to the lordship, Milord.
You are forwarding after the surgery is over. You should have filed
Milord,
for the times with the papers.
Well, the facts of the papers are there.
Mandamus means mandamus preceded by demand. There is no demand at all. Of course, your representation at page number 78 is very clear. Not your representation, Government of Meghalaya. Communication is there, there was a representation. So we take that.
Well, your 2 minutes, your lordship, kindly hear me, Milord. Your lordship, kindly hear me. My lord, if your lordship kindly take the trouble of just 2 minutes, Milord.
Yes.
If your lordship must see one page, WPC 121, Milord. WPC 121, Milord.
What?
121.
Um, 121.
My lord.
Which is 121? Oh, case
WPC
121. Page number?
Page number 87, Milord.
60?
87.
37. 37.
87, Milord. 87.
87.
My lord.
Yes.
This was a representation submitted by the association in 19. Thereafter, another representation, Milord, at page 89.
With regard, I am to inform the policy on remission, so on, so on. So, yes.
Then another representation, Milord, at page 89.
Oh, your representation.
Then petitioner submitted at page 91, Milord.
Yes.
So representations were duly submitted. And Milord, you will also see for the earlier VAT remission also, they have issued the notification after 8 years. And in this case, having promised for the GST also, how the Hero Honda judgment will be
Sir,
applicable?
we don't want to go beyond the decision of the Supreme Court and also the prayer.
No, the judgment of Supreme Court is not applicable at all.
No,
Because
it's only a mandamus. There is a representation. They will not take a decision. We'll ask them to take a decision. Come. The present writ petition has been filed following relief.
Milord, I have one submission to make, Milord.
Milord, if your lordship may just...
Yes, sir. Yes, Mr. Ashok.
One submission.
Well, can I say two lines, Milord, if your lordship permit me? Milord, at least this is a notice and promise estoppel. They must come up with an affidavit. Without an affidavit, Milord, how your lordship be disposing of?
Yeah, there is no need of affidavit, Milord. I rely on the
Mr. Ashok, it's an admission between the court and the petitioner. It's for the court to decide. There's no need. See, if I'm going to admit, I'm going to grant an entry order, I need to hear the other side. Otherwise, there's no need for us to hear. For dismissing, why should I need the other side? And we are also not dismissing. They are giving you liberty and ask them to take a decision because the matter is pending for more than 6 years. We are asking him to take a decision within a period of 3 weeks or 4 weeks. That's all.
Well, Lordship may keep the petition pending, let them take a decision.
No. Then any of the word to be infectious, that is not to be challenged.
Then your Lordship may, then Lordship may give me liberty. Lordship may give me liberty.
Yes.
That in case I agree.
Yes,
my
we
lord.
are giving you liberty. Yes, Mr.
lord.
Amit.
My lord. Yes, my lord. Kindly see the first writ petition, my lord, and kindly see page 73. Page 73.
Yes.
Your lordship will see consequent upon page 73, consequent to the implementation of Meghalaya Goods and Services Tax Act and subsumation of Meghalaya Value Added Tax 2003, Government of Meghalaya is pleased to resign the Meghalaya Industries Remission Scheme 2006 wide notification dated 16/10/2006. This notification will come into effect from 1st July 2017, my lord. Your lordship is aware that in the year 2017, the GST Act came into existence for central GST and state GST, my lord. And section 1, kindly see the Supreme Court judgment in this regard, my lord, which 2023, my lord, that judgment, my lord. And kindly see the provision, my lord.
Very difficult with regard to
That judgment, my lord, is pointing to a question, therefore. Yes, yes, my lord. 401, paragraph 39, my lord.
1 minute.
Paragraph 38.
One
Kindly
minute, 1 minute. Para number 39 is at page number
38.
4.
403, my lord. 403.
Oh,
Paragraph 38, 403, my lord.
the 38, yes.
Yes. My lord, the section 174 of CGST Act read thus, my lord, and kindly see the last part of that CGST Act, last part at 404 top, 4 lines. Provided that any tax exemption granted an incentive against the investment through notification shall not continue as privilege if the state notification is rescinded on or after appointed day, my lord. So I have shown your lordship at page 41, my lord, the notification rescinding the benefits, my lord.
Whatever it is, he has made a representation. You pass order.
I will decide.
We will give permission or liberty to the petitioner and as prayed for by Mr. Ashok.
I have no issue, my lord. I have no issue.
We'll ensure that liberty is given, all the issues are left open. That's all. You take
Yes, my lord, I completely bow down. But
Yes.
what has the lordship will kindly see
The
the
present
Supreme Court
petition has been
judgment
filed for the so.
my lord.
Full stop.
GST Council has to be implemented in this matter, my lord. GST Council has to be there in this matter.
No, why GST?
No. We are not doing anything. Sir, Mr. Amit. Enough.
Yes, my lord.
Yes.
Kindly see 88, paragraph 88, where the Supreme Court has given the direction to GST Council and state government, my lord.
But
Paragraph
that is
88.
different thing altogether.
Sir, you take a decision. See,
Answer.
you take a decision. If any adverse decision are taken, it's open to challenge it.
Yes.
Yes, my lord. Only thing is, my lord, that now ultimate or final authority in these matters with regard to concession is GST Council also.
Let them pass
And that is the direction which has been passed at page 87, my lord.
We are not going to touch, Mr. Amit, we are not going to touch the merits of the matter.
Yes, my lord. No representation.
The
Who
present
will
reference
decide?
also. So various submissions have been granted. A reading of the prayer would make it very clear that the representation of the petitioner is pending from page number 78. Pending from July 2000. From copy of the representation of the petitioner is pending, as could be seen from the communication dated 13 July 2018, filed as Annexure 10. Full stop. The various factual and legal submissions have been made by the parties, and that GST has come into force as early as 2003, and that there is a CA class. And that the same has been reflected in the judgment of the Supreme Court in para 38. In Hero Motor Corp Limited, reported in 2020-23, 1 SCC 386, the fact that the GST Council is a constitutional body and that any representation is made to the state government as well as to the GST Council need to be addressed and decision shall be taken in an expeditious manner. The Apex Court in the decision referred to Supra has observed as follows. To take para 95 and 96 extract, full stop. Without going into the merits of the matter, we permit the appellants to make further representation, if any, and after hearing the petitioners in person, addition shall be taken by the authorities within a period of, with a competent authority within a period of 4 weeks from the date of registered order. We leave all the factual and legal submissions open, and it is open to the petitioner to raise all the objections available to them, and it is for the authorities to consider the same and take a decision as expeditiously as possible within a period of 4 weeks from the date of receipt of such representation. Full stop. We make it very clear that we have not rendered any finding on the merits in the writ petitions filed by the petitioner in the present writ petition, and all the issues are left open.
My lord, kindly grant some more time, my lord, because these are the matters where consultation may be required. So kindly have it 8 weeks, my lord, because now a fresh representation will come.
Yes, 4
and
weeks,
some...
4 weeks for the representation, additional representation, if any, by the petitioner, and 8 weeks for decision to be taken. We expect that the petitioner shall cooperate and appear before the authorities concerned. In case,
the government also cooperate.
Sir?
The petitioner will cooperate, the government should also cooperate.
Yes, yes, whoever it is, let them appear. The party shall appear. Party shall appear, make the submission. In case of non-appearance of the parties, the same can be recorded and the decision can be rendered on merits. To make it very clear, if the parties fail to appear for the personal hearing, they cannot later contend that the opportunity of being heard is not given.
Liberty may kindly.
Sir?
Liberty may kindly be granted in case the decision comes
Yes, yes.
against me.
We also make it very clear that in case of any adverse orders against the petitioner, it is open to them challenge the same in accordance with law.
My
Grateful, my lord. Grateful.
This is what Mr. Ashok said last time to your junior. But you know, seniors way of presenting is different and juniors way of presenting is different.
Hello, that they don't want to take the blame, my lord.
But you must also allow the juniors to represent. Otherwise, when will they become seniors?
Well, we allow not only thing, even prior to that, we were informed that the government is going to take time. That's why my difficulty was there that we have not prepared also. We were informed that they are going to take time.
No, last time itself we went through the papers and said that this decision we are going to take, you appeared, no? Last time. Who appeared? Somebody appeared.
Well, my junior.
Yes.
Mr. Saiki appeared. Mr. Saiki appeared.
Yes.